Support comes from Mosby Building Arts, designing basements where kids can play and relax. Information at callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky, in for Elaine Cha. A St. Louis man was killed by carjackers while driving for Lyft. His mother sued. But can Lyft be held responsible when killers misuse its app to summon a driver? And St. Louis County Prosecutor Melissa Price Smith has charged presidential candidate Jill Stein with assaulting a police officer on the WashU campus. What will she have to do to prove that case? Also, a state lawmaker came under criminal investigation for calling the state's suicide prevention line. She said she was just trying to investigate its failures. Does her motive matter? These are questions that really only good lawyers could answer. And today, we have three of them here with us. Yes, today is our Legal Roundtable. And joining us to share his expertise is Dave Roland. He's the Director of Litigation at the Freedom Center of Missouri. Dave, welcome.
Thank you, Sarah.
And we're also joined today by Eric Banks. He's the former city councilor for the city of St. Louis, and he's now an attorney and mediator at Banks Law. Eric, welcome.
Thank you. Happy to be here.
And today, a special treat, we're joined by Jennifer Joyce. She was the St. Louis Circuit Attorney from 2001 to 2017. She is now a principal in the consulting firm Vera Causa Group, LLC, and she works with prosecutors around the country in areas such as communications, leadership, and racial equity. Jennifer, welcome back.
Oh, glad to be here.
So we're going to talk about the criminal charges against Jill Stein and another protester in just a moment. But before we get to that, I want to talk about Lyft. The Simon Law Firm, which has had a couple big victories in the past couple years, they took on the ride-sharing app, and in this past month, they got a seemingly pretty big verdict. Now, this firm represents Rochelle Amir. She's the mother of a young man who was killed while driving for Lyft in the year 2020. The people who killed him used the app fraudulently. They were using false names and unverified form of payment. She sued Lyft. Well, St. Louis Circuit Judge Joseph White dismissed those claims. He said that Rochelle Amir hadn't proven that Lyft was a product that's essential to bringing the kind of lawsuit she wanted to bring. The Missouri Court of Appeals has overturned that ruling. That allows this case to finally move forward. Dave, do you see this as an important ruling?
Well, I certainly think that it could be important. I think the one thing to remember about this particular case is it's still in a pretty preliminary stage. So the circuit court had ruled on a motion to dismiss. And what they said is that the plaintiff had not sufficiently alleged what they had to allege in order to even get the court to deal with the merits. And so what the Court of Appeals has done here is they said, well, the basic allegations are sufficient, but now the question is will the evidence presented bear out those allegations? I also think that there was some level of caution to the way that the court wrote this opinion, and I think it's warranted. They noted, look, this is a case of first opinion. We have not previously had to deal with this question of whether a mobile app is more like a tangible product that would be normally considered in a products liability case, or if it's more like an intangible service, which would not be part of a products liability case. So this is our first crack at it, and their best conclusion for the time being is that, well, if the facts end up being like what was alleged in the petition, yeah, we think that this would be a product. But I think it's a preliminary conclusion, not a definitive conclusion.
So let's say this is a product, not just a service. Why does that matter? You talk to somebody who's not a lawyer and they'd be like, okay, I press the button and a car comes to pick me up. Why is this important?
Well, so now to be clear, this is not my area of expertise. And so I'm hoping the other attorneys will help me out here. But there are different kinds of claims that someone can bring when they've been harmed. And if they've been harmed because of a defective product, my understanding is that there is strict liability for the people that created the product.
So it's much easier to hold them accountable.
Exactly. The other option would be to say that they were negligent in some way, and that's slightly more lenient as far as the people that are providing presumably the service. And so for attorneys, we would love to be able to get a products liability case because, again, if the harm was caused, and you can show the harm was caused by this thing, then there's no escaping the liability. It is strict liability.
Yeah.
So, Jennifer, I see you nodding. I know that civil cases are not what you spent your career focusing on, but you know this one.
Well, I actually have kind of a hobby lately where I'm very interested in artificial intelligence and these AI large language models and things like that. I'm kind of obsessed with Claude and ChatGPT. And when I was reading about this case, I started thinking about, wow, what are we going to see in the future? Because this is new. As Dave said, it's a case of first impression in Missouri, but I think they've also looked at this in Florida and Kansas. And I just wonder if we're going to see more and more of this. Is it a product? Is it a service? It's clear, as Dave said, that you want it to be a product because then you have strict liability. You don't have to prove all the stuff about the defendant, their duty, and all that stuff. So it will be interesting to see how this unfolds, and in the next few years, with the AI development going so fast.
Is your sense that AI is one of these things, could be a product, could
Exactly.
be a service?
Well, a large language model, which is how you access the AI, that to me is very akin to the Lyft app. So.
And I thought the court did a masterful job of explaining how we're on the brisk, we're close to uncharted territory here. Yeah. And I think the court used the term that if we use traditional models, it would be like trying to put a round peg in a square hole, something to that effect.
Yeah, that's a good analogy right there, Dave.
Yeah, so as I was reading this opinion, a couple of big issues popped out at me. If we assume that Lyft and other similar apps are products, then I think that does open an entirely new horizon and a potentially lucrative horizon for attorneys that take these kinds of cases, because presumably social media would fall into that category. Presumably dating websites, AI chatbots, Yelp even potentially. So if the creators of these sites or apps could reasonably anticipate ways that their products might be misused to the harm of their users, then they could be on the hook for millions and potentially, cumulatively billions of dollars in damages for harms that are caused using these platforms or these apps. And so I think that the potential implications of this decision are massive, even though at this moment, I think it's still I think this particular decision was fairly narrow.
And this is, as you say, this was a first impression case for the Missouri courts. Does it matter that the court has reached this conclusion here? Does this make, say, the next circuit court judge who sees this kind of case, are they meant to pay attention to what the circuit court has done? Yes, Jennifer.
Well, and it depends. If this is going to be appealed up to the Supreme Court, I don't know. But
maybe with everything at stake, it will.
There is precedential effect in the Eastern District of Missouri created by this case. I mean, it's something that they're going to have to take into account going forward.
One other thing to look for is, how does the legislature respond? It may well be that this becomes like the new rallying cry for conservatives in the legislature, saying, well, we want to avoid the liability that may follow from this, so we're going to specifically create a statute that says that these rideshare apps at the most limited focus, and maybe even any technological development like this, is exempted from products liability claims.
Oh, that would be interesting.
Well, now you gave him the idea, Dave.
Yeah, Dave.
I don't think I gave him the idea. I think they probably beat me to it.
Eric, so this is kind of an interesting case for Lyft. I know you're frequently urging caution for people who are pursuing litigation. If you're there with you get this kind of ruling coming out of the Missouri Court of Appeals, you're there to represent Lyft. Would you counsel them to settle with this grieving mother, make this go away, or to appeal this?
Absolutely.
You would settle.
Every case should be settled.
I love this. Every single case, Eric. But so in this case, you think better, rather than try to take this up to the Missouri Supreme Court, get something that could knock this down, just make this one go away.
I would not charge this hill, no.
I would, because if they don't ask the Missouri Supreme Court to review this, then this decision stands. And I think that potentially that is more damaging to Lyft to have this remaining on the books than it is to at least take a shot at getting the Missouri Supreme Court to review and potentially come to a different conclusion.
So what if you're Uber and you see that Lyft has this thing on the books? Are you saying, Lyft, come on, we got to get together on this. I know we're competitors. Let's take this up to the higher court.
Yeah, I mean, if I was advising the other players in this arena, I would say, you guys need to get together and maybe even offer whatever support you can to encourage Lyft to pursue this in hopes of getting a different decision from the Missouri Supreme Court.
So for everyone who's listening to our Legal Roundtable and thinking, wow, these are some of the most brilliant minds in St. Louis assembled in this room, sharing their expertise on the law. If you have a question for our panel, you can call us at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL On Air. Jennifer, did you have a final thought there on Lyft?
No, I'm going to have to weigh in. I'm going to have to be on Team Eric here.
You would settle.
Because I would be afraid that I would, once the Supreme Court affirms it or even makes a worse ruling for Lyft, I don't know what that would be, but now you have the law of the land in Missouri. It's not just the Eastern District. It's well settled.
Yeah.
And other states are going to talk about it, and I think that I would be more cautious about that. But
yeah, and this is a heartbreaking fact pattern here, having this grieving mother, the guys who abused this app to kill her son. Maybe there'd be some other case against Lyft or Uber through the Western District.
Yeah,
where,
I don't know.
Yeah.
We're cold, heartless lawyers, so we're we're just looking at the law. But
yeah, sure.
It is an extremely sad case for sure.
So let's move to a case that it doesn't have life or death in the balance, but it does have some important First Amendment issues, some other issues involving the criminal code here. St. Louis County Prosecuting Attorney Melissa Price Smith has filed criminal charges against the Green Party presidential candidate Jill Stein, as well as a second protester, a local man. Now, both charges relate to a pro-Palestinian protest that happened on the WashU campus last spring. Price Smith says that WashU police sought charges against 19 protesters. She's only bringing charges against these two because they involve assault on police officers. She says WashU can take the other 17 cases to municipal court. Jennifer, I was somewhat surprised by this because the cases that she's bringing are all misdemeanors. You have some fourth-degree assault, first-degree trespassing, resisting interfering with an arrest. Are you surprised these weren't also referred to municipal court, since there's not a felony attached to either of these cases?
No, I wasn't. I think looking at this case and her actions here, I think that Melissa Price Smith is very supportive of the police. And I think they did a lot to help her get this appointment. And I think she just has the mindset that police should not be assaulted in their duty. And I shared that when I was circuit attorney. And so she's kind of making a statement here by pursuing a state-level misdemeanor on these cases. She's saying that these cases where a police officer is assaulted are of an importance to me that I want to make sure that my office handles these. She's not making a statement on the protest or the merits of the protest or anything else. She's saying don't assault the police. And if you do assault the police, you're gonna see my court system, not municipal.
And how does it change how this case will proceed, that this is going to happen in that state court system as opposed to the municipal court system? Well, even if it's the same charge that they'd bring municipally, is it handled differently?
And it's a misdemeanor. It's nobody's going to go to jail. This is as minor as a case gets in the state system, but it's still in the state system. And one particular act can be a crime in the municipal courts, in the state courts, and in the federal courts. It's just a question of what authority has the case. I agree with her decision here. Reading what's alleged of the conduct of Jill Stein, don't kick the police. I mean, just they have enough to deal with. They don't need to be assaulted. And I've heard people say, well, my God, you have the January 6th rioters that are being pardoned and stuff. How can you do this? Well, that doesn't make this conduct right. So it's going to be a pretty minor case, but I think she's drawing a line that, hey, don't assault police officers in my jurisdiction because then I'm going to charge you if I can.
Dave, are you more skeptical of these charges?
Well, the charge that really stuck out to me was the charge that was brought against. I can't remember his name. The other one who got charged, not the former presidential candidate. But
Jaron Hicks.
Jaron Hicks. So my understanding is that he was a student at WashU, and they brought a trespassing charge. Now, I'm not going to say it's completely unthinkable that a student could be charged with trespassing at their own school. So, for example, if they are inside of a building that has restricted access and they've been told, no, you're not allowed to be here. But that's not my understanding of what was happening. And so I think it's odd that they would have brought this trespassing charge in the way that they did. And to me, that seems to indicate more that they're trying to make a statement necessarily than that they're actually hoping to convict on that charge. And so I don't know what's going through the prosecutors' minds on this. Again, Jennifer's probably the better judge of that. But that's something that stood out to me. It seemed like an unusual charge to bring unless you are particularly trying to make a statement with it.
I think they had been ordered to disperse. Could that make a difference with the trespassing charge?
Yes.
Okay, Jennifer, have you ever brought that kind of case?
We did not. I only brought, we had a lot of protests as I was in office during Ferguson and the immediate aftermath, and we brought a lot of charges, but I did not touch anything that didn't involve someone hitting someone else.
Okay.
Everything else went to municipal court.
Okay. But you could bring a case, the trespassing case. Okay.
Yes.
Interesting. So there is some documentary evidence of what happened that night at WashU, including a St. Louis Public Radio photojournalist was at this protest, and he has a photo that appears to show the police officer pushing his bicycle into Jill Stein, as opposed to vice versa, that maybe she's just trying to almost defend herself from it. Eric, is something like that potentially going to matter in court?
Yes, it will, and that is a particular police defensive tactic. You lift the bike up and you push it toward the crowd. So that does not surprise me, and that's what courts are for.
Right.
So
To sort that out.
Right. It's nobody's saying she did it, she didn't do it, or whatever. At this point, we're just charged. And that, we have a judge and a jury that are going to make the ultimate factual determination here.
So she doesn't live in Missouri. Part of what I find interesting about this is she now has these misdemeanor charges to answer for in a state other than where she lives. Is she going to have to come back and appear in court repeatedly? Is that almost the punishment?
It depends on what the judge requires. I've met judges who would make her come back every time. I've met judges that would let her participate by Zoom. It depends on what her attorneys work out and what the judge allows.
We're going to have to take a break here, but I just want to encourage you, if you have questions for our panel, you can call us at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL On Air. You may have thoughts on the whole Lyft and Uber matter that we were just discussing. We might quickly zip back to that when we come back from the break. This, again, is the Legal Roundtable on St. Louis on the Air on St. Louis Public Radio.
Support comes from Mosby Building Arts, turning unused basements into additional living space. Information at callmosby.com.
Welcome back. I'm Sarah Fensky. I'm here filling in for Elaine Cha because today is our monthly Legal Roundtable. It's always in the last week of the month. We talk about everything that's happened of interest in the local judicial system. Maybe not everything, but a lot of important things. And we put together a top panel of lawyers to do that with us. And today that includes Eric Banks, who's an attorney and mediator at Banks Law. We're also joined by Dave Roland, Director of Litigation at the Freedom Center of Missouri, as well as Jennifer Joyce, who was the St. Louis Circuit Attorney from 2001 to 2017, now a principal in the consulting firm Vera Causa Group, LLC. Now, before the break, we were talking about this issue of Lyft and Uber, these sort of ride-sharing apps, and this could also have big repercussions for things like ChatGPT, other tech aspects. Are they a product or are they a service? Well, we have somebody ready to join our conversation. Gus, calling from St. Louis, has some thoughts on this. Gus, hi, you're on St. Louis on the Air.
Thank you for having me. I'm not a lawyer, but I'm just going on this theory from my academic point of view. When all these products, we call them products, when they are developed, there is a patent and there is a liability on all of them take out insurance for liability. So if there is a patent that is protected, why shouldn't it be their product?
Gus, I think that's a great question. Thank you for raising that question. This idea of if you go ahead and have a patent, and maybe if you have liability insurance, does that maybe invoke that you are a product, as the Missouri Court of Appeals found? Dave, you look very quizzical, like you're thinking through this question.
Well, I'm thinking through it carefully because, again, this is outside of my typical area of focus. And I'm trying to think through the implications of all of that. I think that most service providers have insurance just in case something about the service that they provide ends up leading to harm for their client. And so I'm not sure that merely having insurance would be an indicator that a company is producing a product as opposed to a service.
Mm-hmm. What about that patent question, though? I don't think a service would get a patent, would they?
Well, but I think that you can patent ideas, can't you? Like, so you're not necessarily patenting a tangible device. And that's kind of, as I understand it, that's historically been the dividing line for products liability. And so one of the things that the court wrestled with in this case is this more like a tangible product, or is it more like something that is intangible? So I'm not sure that merely getting a patent would tip the balance. But again, I could be wrong. I'd be interested to hear what the other panelists have to say.
Yeah, I don't know if either of them want to take this. I see some no's. They were happy that I put you on the spot with that one. But Gus, you raise a good question, and I think this is something we're going to continue to explore in the coming months. So thank you. And again, if you have a question for us, 314-382-8255. That's 382-TALK. A state lawmaker was under criminal investigation here in Missouri, and her crime was that she called the state's 988 suicide hotline. Tricia Burns of Wentzville said she wanted to expose deficiencies in the system. She sent some texts saying that she herself was suicidal. Well, police responded, perhaps suggesting the defects weren't as huge as she had thought they were. Then the Missouri State Capitol Police opened an investigation, and this was into Burns herself. She said she sent the texts in the state Capitol building while meeting with representatives from Compass Health Network, which operates the behavioral crisis centers in the states. She said, quote, "I was testing 988 under the guidance of 988. Jennifer, does that motive matter when it comes down to the potential of criminal charges for misusing this kind of hotline?
Not from a legal perspective, no. And, hats off to her for trying to improve things. I've never met this woman, but I have to say, not as a legal matter, but as Jennifer Joyce, who's been on the planet a long time, that I think she exercised pretty poor judgment in testing it that way. Having said that, I'm puzzled as to what kind of charges would be brought against her for this. I cannot find a crime in Missouri law where this fits. The two that immediately came to mind were obstructing government operations, but as she said herself, this is Compass Health Centers, and even though it triggers government action, it's not a government entity itself. And then making a false report, it seemed like possibly, but that's only if you call 911.
Oh, it might not apply to 988.
It does not apply here. Right. So I think this is a case of, I would have liked to have seen her use a different approach with this, but I'm not sure that she has committed a crime.
It's interesting to see an experienced prosecutor weigh in on this because it turns out, sort of breaking news, that is what happened in this case. The Cole County prosecutor said he's not going to file charges in this case. So we have some consensus among our prosecutors.
Do you know what they applied on? What charge?
That I don't know.
Okay.
Yeah.
I think it was, I think they applied for a false report.
Okay.
So maybe that came down to 988 versus 911. Settled matter. So here's something that's not really a settled matter, just a very sad case. Attorney Gerald Christmas, he's often in court seeking leniency for his clients. He's a prominent defense attorney here in St. Louis. Last month, he went to court to blast the leniency given to a killer. This is the man who killed his brother. John Christmas was killed at a convenience store. He'd gotten in a dispute with a clerk, and a man named Travell Warren inserted himself into this interaction, tried to steal John Christmas's gun. The dispute ended up outside the store. When both men were on the ground, Travell Warren shot John Christmas with his own gun and killed him. Now, Circuit Attorney Gabe Gore agreed to a deal where Travell Warren pled guilty to involuntary manslaughter, and he got just 7 years. And that's for taking a life. Gerald Christmas, the defense attorney, he says that would have never happened in a killing if it happened south of Delmar. Eric, do you think that Gerald Christmas has a good point here, that we have a different standard?
He has a good point. I'm not so sure that I would express it the way that he did. Things are getting better. We have to be very vigilant to make sure that they continue to get better. And when we have somebody of Gerald Christmas's unquestionable status raising these concerns, we all should pay attention to them.
So it wasn't just him who came in to sort of try to fight this plea deal. There were also 2 municipal judges who serve in St. Louis County who showed up to court to tell the circuit judge, don't accept this deal. I was fairly surprised to see that, to see a couple judges come in and try to influence another judge. Should I have been? Is that something you've seen in your years of practicing?
I have not seen it, but I don't think that judges give up their First Amendment rights once they become judges. And some would argue, well, who would be better to offer constructive advice to a judge other than another judge?
Yeah, because they know what this judge is grappling with.
Yes.
So one of the things that I think you're absolutely correct. Judges do not give up their First Amendment rights. But one of the things that I think judges need to be attuned to is the concern that weighing in on a matter like this could call into question their own impartiality. And so that could prospectively have some impacts on the kinds of cases that they are able to review. Now,
that somebody could raise this and say, hey, you were publicly quoted
exactly.
on this. I don't want you hearing this case.
Exactly. So I don't know that in any specific case that it might come up that you might have a recusal motion, but it is the kind of thing that I think could be relied on to say, hey, you know what, this judge can't hear this case because of what they said here. Mm-hmm. I do think it's an incredibly sad situation, and I think that I can't fault Mr. Christmas for his comments because, I mean, again, this is his family member.
Yeah.
I wouldn't expect anybody to be more measured when they're dealing with those kinds of emotions. But I also think that Eric is absolutely correct. I think that circumstances are improving. I think there are still very clear concerns about whether equal justice is being applied. And I think that particularly noting that it sure seems like the courts are applying justice differently based on whether people live north or south of Del Mar is still a valid concern to raise and one that should be paid attention to.
And yet, for prosecutors, this is incredibly hard. You have this kind of case. Jennifer, can you shed some light on what Gabe Gore's office might have been thinking or should have been thinking about?
Well, and I also want to touch on the municipal judges. I agree with you, Dave, that it's probably not the best look for them to be expressing an opinion in a case. But in this particular instance, these are municipal court judges. They are never going to sit on a homicide case in their capacity as municipal judges. You know, they're not going to have a similar case. And I think we can all agree that this case is just unbelievably sad. Gerald Christmas was a former colleague of mine. We worked together in the Circuit Attorney's office. And I have lost a sibling to cancer. I know how painful that is. I can only imagine what it's like to suddenly lose a sibling like that. Mm-hmm. So my heart goes out to him. However, this is a really tough case for the prosecution. And it would be a tough case if it took place in St. Louis Hills, and it would be a tough case if it took place on Goodfellow. It is what it is, and I don't like to hear things like people just loosely saying this is a different result because the victim was Black. I just don't think that serves any interest in a case like this. The complexities here have to do with all kinds of things. They have to do with the castle doctrine, stand your ground. This was a wrestling fight over a gun. That's extremely messy to try and parse out who did what, why did it happen, et cetera. After thinking long and hard about this and talking to other colleagues, I think that really this is a reckless defense of others claim here. You know, you can do self-defense, you can do defense of others if this guy's going for the gun that Gerald Christmas's brother had, but you can't do it in a reckless way. And that's a separate thing that the jury would hear about. So this was never going to be anything more if it went to the jury than a manslaughter case. There's just no way.
So trying to get more than 7 years for this.
Right. And that is just a fact. There's a video of it. I have not seen it, but my understanding is that that's something that the prosecutors poured over. And, you know, sometimes you have a case that just is going to be impossible to prove at a certain level. And I take umbrage at the suggestion that this is because of the race of the defendant and the race of the victim or where this case took place. And as much as my heart goes out to Gerald Christmas, I think probably he knows as a prosecutor that there are cases that are difficult. If he was the defense attorney on this case, he would have a field day.
Pointing out all the possible defenses.
Exactly.
Yeah. I think one thing that made this case a little complicated, I mean, there's so many things that make this case complicated, as you've done a good job of pointing out, is that at the time that Travell Warren showed up at this convenience store, he was out on bond for a case where he had been charged with being a felon in possession of a firearm.
Yeah, he was on a bracelet.
Yeah. And so people are saying, well, he could have gotten 7 years just for that. My understanding is very few people end up getting 7 years for that.
No.
Okay.
And in fact, he had multiple violations on his ankle bracelet already.
And nobody brought him in.
Yeah, that just doesn't happen. This is just such a tragedy. It didn't need to be that way, and I think that but for his actions, this would not have happened. And I think that's really what it comes down to. But the circumstances and the wrestling over the gun and you can't really see what's going on, all of that just make this a really, really tough case.
Eric, I'm going to give you the last word on this one since I gave you the first word on this one. What's kind of your takeaway as you look at this case?
Well, getting back to whether or not what the judges did was ethical or not, not only are they municipal court judges addressing a circuit court judge, there's also the geographical difference. These are St. Louis County municipal judges addressing a St. Louis City judge. So I go back to the idea, well, who else can offer constructive advice to a judge other than another judge?
We're going to take a quick break here. We're talking to our Legal Roundtable. That is Eric Banks. We're also joined by Jennifer Joyce and Dave Roland. When we come back, we're going to talk about a jaw-dropping Sunshine Law case. We may also have a discussion of juror pay. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm here with our Legal Roundtable. Today, that is Jennifer Joyce, the former St. Louis Circuit Attorney, a principal now in the consulting firm Vera Causa Group, LLC, that works with prosecutors across the U.S. We're also joined by Eric Banks, who's an attorney and a mediator at Banks Law, and Dave Roland, who's the Director of Litigation at the Freedom Center of Missouri. So, Dave, I got to direct this next one to you because it involves one of your cases. And this one, I said jaw-dropping before the break. I sometimes like to hype things up. I am not overhyping this. This is a Sunshine Law case where you've been seeking public records along with Aaron Malin, who when you began this quest was a law student. He's now a full-blown lawyer. You've been trying to get records related to multi-jurisdictional drug task forces across the state of Missouri for 10 years. You guys have won victory after victory after victory. You still don't have the records.
Yeah. So next Tuesday will mark 10 years since Aaron asked for these records. And he was not yet in law school when he was asking for these
prior
records.
to law school.
It was before he even went to law school or before he even applied for law school.
Wow.
So yes, we did win a long series of victories, including the most recent one in 2023. The Court of Appeals says, yes, in fact, the prosecuting attorney's office has to locate these records and provide them. The issue with the motion for civil contempt isn't so much that they haven't finished searching for and providing the records, although we are certainly frustrated with how long that's taking. The issue is that last July, the court ordered the prosecutor's office to provide monthly updates. He said, all right, I want you to keep a log of the search that you're conducting, and every month, no later than nor less frequently than the end of every month, you've got to provide a copy of that log to the plaintiff so we can keep track of the progress. Well, Sarah, they just haven't been doing it.
They're not even doing the monthly log?
No. And they're not providing all of the information that the court said was supposed to be included. And so a couple of times I told the attorney for the prosecuting attorney's office, I said, look, I understand. This is a complex search. That's why that there was no, date certain by which it had to be concluded. But the court did give you pretty specific instructions about what you're supposed to be doing. And if you don't start doing it, we're going to have to take steps to hold you accountable. And then for the next 3 months, they did not do anything remotely compliant with what the court had ordered. And so that's why we filed the motion for civil contempt. They did file their response yesterday. And the thing that is frustrating and interesting to me is they didn't even try and argue with the facts as we laid them out. They didn't argue, well, yes, in fact, we've been complying with the order. They basically argued it really shouldn't matter. They said, here's where we are with the search now.
Okay.
And we hope to be able to wrap up, at some point in the future. We didn't do this on purpose.
Really? They're just saying, you told us to do a monthly log. We don't have to do a monthly log. To me, the monthly log feels like the easy part. I would do the monthly log just to keep the judge from giving me a hard time.
Well, and so I don't know about my colleagues here in the studio, but if a judge tells me to do something, I prioritize doing that thing because I would be worried that, opposing counsel might file a motion much like the one that I filed and that the judge would then hold me to account for not complying with the judge's order. And so it really has kind of blown my mind that even when we went back a couple of times and said, hey, look, the judge specified this is what you need to do. I need you to do this thing. Yeah. That it did not produce results. Now, again, I can't climb into the mindset of attorneys on the other side all the time, but maybe my colleagues will have some more perspective on that.
Jennifer wants to hop in here. Okay.
Yeah, let's hear it.
No, I certainly I did some digging in this because listening to your interview the other day, I was scratching my head. I have some thoughts on what it's like as a prosecutor to receive these kind of requests. But what I couldn't understand is why Mark Richardson would not respond, the original Cole County prosecutor. I've met him a couple of times, don't know him personally, and I don't think I've ever met the current prosecutor. But I got nothing on why he acted the way he did. I cannot explain that, and I think he was wrong, and I'm glad that you pursued it. But I will say, in defense of the new prosecutor, he inherited this. mess,
Yeah.
okay, that was created by his predecessor for reasons I can't explain and will not try to defend. But running a prosecutor's office, that you don't have a bureau of sunshine law people who are going to be standing by with nothing else on their plates ready to go through this. It's my understanding that they have, you said they haven't complied at all. They haven't turned over any documents. Well, they have turned over documents. As they find them, they turn them over. Right now, they're down to a microfilm search, which has to be off premises.
Oh.
And that takes forever for them. And he doesn't have the prosecutors to cover his divisions right now. So what judge is going to go without a prosecutor in the division? What case is going to not be heard? What victim is not going to get justice because they're looking at the microfilm? They have to do it as they can fit it into their work. And there are people, and I'm present company accepted. I respect and admire the work that you do, Dave. But there are people that use sunshine law requests as an abusive tool for prosecutors. I've seen that many times, knowing that they're going to get snowed in, that they don't have a lot of excess right now. And it's worse now than it was when I was in office. Almost every client I have across the country is shorthanded because people just don't want to be prosecutors and they're not applying. But it takes so much time and effort to do that. It's important. I'm not saying it's not important, but some people abuse it, and it's a tough situation for prosecutors. So I'm saying nothing to defend Richardson.
Sure. He should not have sat on this.
He should not,
until
and
it
he
became
created
a
this
microfilm.
huge mess for this new prosecutor, who I believe is doing what he can to get the information. They've done computer searches. 2 lower court judges have found that they've substantially complied. It's my understanding now. I don't want to get into a granular discussion of this with you, Dave, because obviously I'm not going to be able to do that.
Sure.
But I do know that there's another side to this. This guy is not blowing this off. He is working hard on this. And maybe if we want prosecutors to turn around that fast on stuff, we provide them with some resources to have a person who's in charge of replying to sunshine requests.
I love that idea. I think we, the taxpayers, should do that. Give them a designee. I wish City Hall could get a better designee. But Dave, I know you want to jump in here.
So a couple of things. I want to point out that to the extent that lower courts had previously said that they had substantially complied, those courts got reversed on that. That was 2 of our trips to the Court of Appeals.
Well, the second time to the Court of Appeals. The first time the Court of Appeals affirmed them, though.
They affirmed the decision not to find contempt. They did not affirm that substantial compliance was sufficient for satisfying the original judgment, which is why we got sent back down for continued enforcement of the original judgment. I never said they never provided any records at all. They have been providing records in dribs and drabs. What they have not done is complied with the order that the judge
log
issued last July, and they have not completed the search and production of records. Part of the issue, and again, this is going to come up when I talk to the judge about this next week. Part of the issue is that they did not begin by putting together a comprehensive list of the officers whose records were supposed to be produced. And so they conducted the electronic searches, I think, 4 years ago, and they have been finding new names that should have been included in that search. And it's not at all clear, even from what they filed yesterday, that they've gone back and included those names for a search of the electronic records. So in other words, if you have an incomplete search to begin with, once the new information becomes available, you got to go back and do that search again, including the new information, or you haven't complied with the original judgment.
So I'm going to hop in here in my role as host of this show, and I'm going to appoint a jurist here to sort through these claims. I feel like I now have greater appreciation for what judges have to do, because this is incredibly complicated stuff, and I think Dave knows this case backwards and forwards.
If I could just say, I am not disagreeing with Dave from a legal perspective. I'm offering that this is not a prosecutor who doesn't care about this who...
You're helping us understand the context.
Exactly.
Yeah.
But I'm not saying that we shouldn't have... I would love to have a new Sunshine Law statute. It's from 1973. It's older than... I mean, it's unworkable.
Very ineffective in many ways.
But it's important.
We could have a whole show on that.
It's important, and I appreciate the work that Dave and those like him do on this. I don't want this guy to be cast as a villain here because I think he's got a bad situation and he's doing what he can.
Well, so I'm going to go to our judge, Eric Banks. What do you think?
Actually, it would be a special master if I'm
Special
appointed.
master. There you go.
Well, and I'm not buying the idea that the prosecutor's office is overworked and underpaid and everything because you have to pay for those Sunshine Act requests. And the ones that I submitted, they look like these are outrageous charges. How much does it cost to have a clerk look through the records? So any type of cost that the prosecutor's office incurs should be borne by the people requesting the records.
You know, in this case, Eric, they can't do that because Richardson didn't ask for that early on.
So once again, the original prosecutor
he created this
up.
huge mess. And so, I mean, that would solve a lot of the issues.
Well, our special master has ruled. We're going to have to take this up to the appellate court. But yes, I appreciate this lively discussion. I always encourage my panelists to disagree with each other, and I think there's been some great points made here. I'm going to bring up something that I think, for our final topic today, I think is probably a little less hotly controversial, and that is Missouri Supreme Court Judge Mary Russell wants state lawmakers to raise juror pay. She noted that mileage compensation for jurors is currently at 7 cents a mile. I can't even say that without laughing. And best I can tell, the state seems to be paying jurors $6 a day. Now, I understand different jurisdictions can add to that. Jennifer, you were saying the city currently pays jurors $18?
Well, $12 a day, but if they get picked for a jury, $18.
Okay,
but as
so
was
again,
pointed out, that's not lunch and parking.
Right.
And the 7 cents a day, I don't know, are they riding their bike,
Yeah.
walking there, you know?
So what's the ramifications of having such a badly paid group of jurors? Does this have an impact on the administration of justice?
I think so. As someone who's tried a lot of jury trials and had a lot of trials in my office, it's critical that we have a jury pool that is composed of a cross-section of people who have jobs, people who are working, people who have families, maybe also some younger people who are looking for jobs, a variety of people. We can't just have the jurors be people with nothing better to do. Mm-hmm. I'm going to come down. I don't have a job. I don't have any reason to not come to jury duty. I mean, we have to make it attractive to people. It's a civic duty, but we also have to make sure they're not losing ground by going. And in Missouri law, they don't have to take their vacation or sick time, but they're still missing that day of pay. And if on top of that, they can't pay for their parking and their lunch, I think we're getting to the point where it's not rocket science to get out of jury duty. I shouldn't say that. But
I'd like to know some tips, but no, I think you make
if you're
point.
hell bent on getting out of jury duty, you can get out of jury duty. We want people to want to be there and to appreciate the importance of their service, and gotta compensate people.
Eric, $18 a day, $12 if you're waiting to be paid.
It is insulting. Yeah. And how can we expect our jurors to respect the judicial process if we don't respect them?
How high would you like to see this raised?
Market rate.
What would be market rate? Are we talking $1,000 an hour for a top attorney who gets called for a jury? I mean,
at a minimum wage.
Okay, I like your thinking
on
that.
The state minimum wage, not the federal minimum wage.
Yeah, talking $15 an hour or whatever it's about to be raised to. I like that idea. Dave, in our just final 30 seconds here, can you get on board for that?
Juries are the linchpin of our judicial system. They are absolutely indispensable. And we have got to provide a sufficient amount of compensation so that Americans can, with economical feasibility participate in that system. And so how high should the rate be? I'm not qualified to answer that, but I think that we've got to be, as a society, prepared to provide whatever level of compensation is necessary to ensure that all Americans can participate and are willing and interested in participating in the jury system.
Amen.
Yeah, amen. Preach it. And I like what our special master here said. It seems so simple when you break it down that way. Why wouldn't it be a matter of minimum wage? Eric Banks, attorney and mediator at Banks Law, thank you for joining us today.
Thank you. It's been a pleasure.
And Dave Roland, director of litigation at the Freedom Center of Missouri. I want to thank you so much for joining us.
It's always a great time, Sarah.
And Jennifer Joyce, a former St. Louis Circuit Attorney, also a principal in the Vera Causa Group, LLC. Thank you so much for coming and sharing the prosecutor's perspective.
It's the fastest hour of my day.
Time does fly. And I just want to encourage you, those of you who are interested in the Legal Roundtable, we are always, it always takes place in the last week of the month, so you can get a sense of when to look out for it. You can always find the podcast wherever you get your podcasts. That includes Spotify, Apple Podcasts on the App Store, and other places as well.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.